we're going to just go ahead and jump right in. This presentation, the second half of this presentation is going to cover general FEMA eligibility, which some of that has been touched on, so that's great. And then we're going to talk about some of the more recent changes that occurred at the beginning of 2024 under the Biden administration to the FEMA Individual and Households Program. And these will be changes for the FEMA applications that are currently ongoing. And so if you've worked a disaster prior to 2024, there are going to be some differences that you're going to need to catch up on a little bit going forward. And then I'm going to pass it on to Hannah, and she's going to go over some common FEMA appeals and types, documents, and things that you will likely see if you're helping a disaster survivor with FEMA-related legal issues. Next slide. So in order to ground all of this in some context, because we're about to throw a lot of information at you, Hannah and I both agree that it's really helpful to kind of understand the steps of what a FEMA case looks like before jumping straight into the law on a FEMA case, so you kind of have an idea of where to place these arguments. So if you work at a legal service organization, or if you're a pro bono attorney who's helping disaster survivors, you're going to want to get all your normal administrative documents right when you meet with the disaster survivor if you're going to do an intake and represent them. So for your LSC, those are all your normal admin docs, your representation agreements, things like that. Something that's going to be applicable for everyone who's representing a survivor in a FEMA case is you're going to need a client ID, a photo ID. So whether that is an LPR card, a driver's license, a state issued ID, it can be a passport, anything like that. You're going to want to have a copy of that because you're going to need it throughout the process. And then there is a government form for a third-party authorization that allows you to speak to FEMA and submit documents to FEMA on behalf of your client. So you'll want to go ahead and get that done pretty quickly. And the reason why we tell attorneys and advocates to go ahead and do that is because sometimes you might lose contact with your disaster survivor at the very beginning because they're a little more transient than normal. And this will at least allow you to start getting information on their case right away. With that client ID and FEMA authorization faxed in or mailed into FEMA, or even given to them at the Disaster Recovery Center so they can upload it into your client's file, that will allow you to speak to FEMA without having to have your client in person or on the phone with you every single time. Like I said, sometimes your clients might be a little more transient, and it's really difficult to get them to sit on a phone for 30 minutes to talk to FEMA while you try to figure out why FEMA keeps denying your client assistance. If that third-party authorization form will allow you to do that without them there. If they've applied online, that can be helpful. Two things there: you can upload that ID and FEMA authorization that way, so that makes that happen really quickly. The other thing we typically see there is FEMA will send the determination letters to the online account rather than mailing them, which in this situation might actually be better. But a lot of times what we see in Texas is our elderly clients may not be the one that applied online. It may have been a grandkid or somebody, a child who was trying to help them do that, and they don't realize that they're actually getting these notifications from FEMA in their online account. So just kind of check with them, make sure that they know where their documents are going to go. The next thing you're going to want to do when you're talking to your client is determine if there are any deadlines that are coming up. So general FEMA appeal deadlines are 60 days from the date on the letter. Note that that is different than the typical mailbox rule we're all used to seeing. It's not a postmark date, it's the date on the letter, which actually means you're going to have less than 60 days to do your FEMA appeal. Now, there is a good cause exception that can apply for a late appeal, and it's pretty flexible with FEMA, but you're going to have to explain that to them rather than just submitting it late. So just kind of keep that in mind. General rule, 60 days from the date on the letter. There are shorter deadlines in some of the determination letters that your client will receive from FEMA. Sometimes they're 15 days, sometimes they're 30 days. Those are generally when FEMA is asking for supplemental information. They need an extra document, or they need something else explained to them. So just make sure you thoroughly read the determination letters. Determination letters can also have more than one denial reason on them, so you'll want to know that. And you can get different determination letters one after another. So you'll want to kind of keep track of these deadlines. As best as you can. One of the first things I do, and I have my staff do when we start representing a disaster survivor, is when we submit that client ID and that third-party authorization form, we go ahead and write a cover letter saying, hey, we want a copy of our client's FEMA file. Know that in active disasters like the one you are currently in, because it is so large, you will likely not get your client's FEMA file in time for your first appeal. You're going to kind of have to go into it blind a little bit. So going ahead and getting it in so it can that request in and getting it in the queue, that's best practice so that you can use it in the future to review. But you're really going to be relying on what your client's telling you, what documents they've provided to FEMA that they can show you, what they've said to FEMA on the phone. And so sometimes for us attorneys, that's a little bit of an uncomfortable place to be, but it is very common when working on these cases that you will not get that FEMA file right away. So you're going to want to figure out what your client has already submitted and confirm the number of inspections that have happened. I use that as a personal marker for me to figure out if my client or if FEMA has considered something my client submitted as an appeal. So FEMA, once a survivor applies for FEMA assistance, they usually issue an inspection within 10 days. FEMA generally doesn't like to do more than 2 inspections. So if my client has told me that they've already had their second inspection, that tells me that FEMA has received a document or information from my client that made them send out a second inspector. So I'm going to want to know that and figure out what they submitted that they considered an appeal in order to supplement that or maybe kind of combat that. So that's just kind of a little trick that I use. And then finding out if they received any documents after that second inspection will be really important. Next slide. So then you're going to gather all of the documents that you need based on the denial reasons, which Hannah's going to go over in detail what that looks like and what documents you're going to need in a very simplified form for you. You'll submit them all to FEMA. There's multiple ways to do that. They're listed here. Under that new policy change in 2024, FEMA no longer requires a written signed cover letter for you to submit your documents. They still require the third-party authorization and they still require your client's ID every time you submit an appeal, but you don't have to do a cover letter to explain that. Now, I would say best practice is to go ahead and draft up a cover letter. But if you have something simple, like your client was denied for home ownership and they have a warranty deed, submitting that to FEMA without a cover letter probably is going to resolve their issue because it is a common document that FEMA workers are going to be likely to understand and register as this is a deed. This means they own the house. If it is something more convoluted, like in Texas, we have affidavits of heirship or different types of state-specific documents, I'm going to want to explain that to FEMA and let them know that this is recognized in Texas. This is recognized in California as ownership. But just keep that in mind. I typically call about 1 to 2 weeks after the FEMA appeal has been submitted. In large-scale disasters, FEMA can take their time in reviewing these appeals and processing them. Generally, their rule is 90 days from the time the appeal is submitted. Sometimes that happens much faster. After Hurricane Harvey, sometimes that took much longer, and there's not really a way to enforce them to make a decision in that time. So just frequently call back, maybe every 2 weeks or so. And then the other really big important thing that's different than your typical practice or litigation practice is that even though you have alerted FEMA in multiple ways that your client is represented and that you are the attorney on the case, they're going to send the determination letters to your client. They're not going to send them to you. They're not going to call you. They're not going to tell you anything. So you have to try to keep communication up with your client and let them know that they need to notify you of these. if they are receiving their notifications online, if they will give you access to looking at that, then you can have a paralegal or another advocate review their online application to see if they've received any new alerts from FEMA. But FEMA will send you the case file directly, but they will not send the determination letters with the deadlines on them to you. So maintaining that client relationship is going to be important. Next slide. Okay, so that's a general rundown of a case. So general IHP eligibility, Alexandra did a great job covering some of this immigration stuff. So I'm gonna just defer to what she said on that for all of your sakes. But yes, US citizen, non-citizen, national, or qualified alien. And she had some really great definitions there. So review those slides. In Texas, we do a lot with representing minors in households who have status, and then other members of the household who do not have status. We do that frequently. I will just reiterate what Alexandra said, which is we are now in a new administration, and historically, FEMA, even though it is under the DHS umbrella, and there is the Privacy Act statements and the statement that says that they can give information to ICE. Historically, FEMA has not done that. We don't know what that means for this administration, who has different policy goals than what they have been in the past. So I would just do my best to explain both options to my client, let them know the pros, cons, risks, and then ultimately that's the decision that they have to make and what they're comfortable for. But that's the standard. Next slide. So the other thing, in addition to having a qualified status, is that the applicant has to reside in a disaster declared county at the time of the disaster. They have to have disaster damage, and that's going to be confirmed by that initial FEMA inspection after the application is submitted. And then they are going to have to show that they have insufficient or no insurance coverage. And if there is a significant delay in the insurance proceeds, then FEMA can assist, and the survivor can then ultimately repay FEMA based on their insurance proceeds. Next slide.
I'll flag quickly. We're already hearing from folks that they're being told you have insurance and you shouldn't proceed with your application, which I'm sure is something FEMA does.
Yes, it is. And that's a great point. It's going to be important to explain to people that they should simultaneously apply with their insurance and FEMA at the same time. And then if there is an unmet need that insurance doesn't cover, FEMA can potentially cover that. So just because they have insurance doesn't mean they're automatically precluded from FEMA assistance. The other thing is there to watch, something that we used to see happen a lot is survivors would say, my home was damaged and yes, I have insurance. And so FEMA would deny a survivor because they stated they had insurance, but in reality, their home was damaged and they had vehicle insurance or something like that, right? Like they were just generalizing on the question. So you'll want to kind of make sure to clear that up with your client because obviously vehicular insurance is not going to cover the damage to the home, but FEMA's application is just a series of yes and no questions and tick boxes. So it doesn't really allow a lot of room for elaborating on each individual application. So the Individual Assistance Program Equity Rule was a policy that occurred during the Biden administration when they were engaged in this sprint towards equity. And so they overhauled some of the FEMA disaster recovery IHP programs. This is a summary of some of the changes. It was a pretty extensive, an extensive rule change, but the big ones are kind of listed here. And we'll go over them in a moment, but some of the bigger ones are they've changed the definition of what habitability is for the purposes of being able to receive home repair, home replacement assistance. They've also removed the requirement that disaster survivors apply for a small business loan in order to receive other needs assistance like personal property or transportation assistance. So that is a huge barrier lifted. SBA is still available. It can still be there to supplement or add to FEMA or in lieu of FEMA completely, but it is no longer required. There are new appeals forms and streamlined deadlines. And then they created a new displacement assistance program. And then they changed the critical needs assistance program that previously existed to make it apply for every disaster. And they've renamed it to the serious needs assistance program. Next slide. So generally, under FEMA IHP, there are two types of programs. There is the housing assistance program and then the other needs assistance program. And in the most simplified way, housing assistance covers housing repair, home replacement, permanent housing, and temporary housing like rental assistance and transitional sheltering. Other needs assistance is going to cover a survivor's personal property, transportation, all of these items that are listed here. And there is a max amount of money that FEMA is able to pay a disaster survivor. And so a disaster survivor is eligible for up to, I think the 2025 update is $43,600 in housing assistance and in other needs assistance. So that's, I'm not great at math, but that's like a total of close to $90,000, I believe, that they can get in both out of both of those buckets there. So thoroughly going through the types of damage that your client sustained will help be able to get them access to that larger amount of money. Next slide. Next slide. So we're going to jump into the housing assistance programs, and we're going to start with temporary sheltering assistance. Now, this might be something that you see or you have seen in other disasters. This is typically what people will call the FEMA hotel program, where survivors go online, they find a hotel that FEMA has a partnership with, and then they're able to go stay there. Sometimes it's for a week, 2 weeks, can be up to a month sometimes. And this is a direct voucher program where FEMA, the government, pays the hotel directly. No money goes between FEMA and the survivor for the purposes of sheltering in these hotels. And this assistance is available to survivors. It's supposed to be short-term assistance, but after Hurricane Harvey here in Texas, people were in them for months at a time. And that all depends on the housing, whether there's a housing shortage or rental crisis in the area. So it can be extended for 14-day intervals up to 6 months. But that is a type of assistance that might be available to your survivors. Next slide. Temporary housing units, this is what people often call FEMA trailers. These are usually manufactured homes or mobile homes, but they can come in the form of a military base housing. Cruise ships can be occupied, docked, and then turned into temporary housing units. And this is available if a survivor's home is destroyed and or is deemed uninhabitable. Rental assistance and rental assistance is not available because of a housing shortage in the county. So it can last up to 18 months. It can be extended upon request from the governor. And then it's important to know that a survivor who receives a temporary housing unit, the cost of that housing unit does not come from that max award of the $43,600. It won't impact that max award. So it is a completely different type of assistance that is open and available to them. Next slide. Rental assistance is by far the more common thing that we see. Those temporary housing units usually take several months to come in and play a part, and there are often a lot of issues between the county and FEMA as to what is zoned appropriate for those homes. So often what we see is rental assistance, which is cash payments to disaster survivors for rent, and this can pay for rent, utilities like water and electricity. The initial rental assistance payment is usually done by request. So when they are applying for FEMA on the application, it will ask them if they are displaced, if their home is uninhabitable or inaccessible, and then if they are willing to temporarily relocate. Now, often what we see when people don't get the initial rental assistance request is because they say they're not willing to relocate. And a lot of times it's because the question is worded in a way where it makes it seem like it's a permanent housing relocation, and it's not, it's temporary. So you can fix that for a survivor who did not get an initial rental assistance request by asking FEMA to provide rental assistance that they're willing to temporarily relocate, rent while they repair or rebuild their homes. But rental assistance is available for 18 months, generally can be extended by the governor, and a survivor after the initial rental assistance request will have to recertify their request every 2 to 3 months. And Hannah will explain what goes into that recertification. Next slide. Home repair assistance is also a really large form of housing assistance that we see. Applicants have to be able to show that they are a homeowner, and there are different standards that FEMA uses. So FEMA abides by state law when they're operating in the state, and so official deeds, deeds of trust, other official records recognized by your state, they will accept those as proof of ownership. FEMA also has a different standard of ownership for individuals who don't have that traditional documentation. So as long as they can show that there's a list of documents that's available to them, but generally they have to be able to show that they're not a renter, that they pay the property taxes or are responsible for the home's maintenance. They can also provide receipts for major improvement to support that claim, or get statements from an official that explains that they live there. So maybe someone from the Postal Service, but that's generally the rule. And then if they are unable to meet that official or that unofficial standard, there are two types of affidavits that can be used as a last resort. That is an heirship property affidavit, which allows homeowners who have inherited their home with not clean title to be able to explain that in an heirship affidavit. And then there is a separate one for individuals who have a mobile home or manufactured housing unit, and maybe they don't have a clear statement of, oh, I can't think of the word now, SOI, that explains their ownership on that. They can use an affidavit to explain that as well. If it's a will, can be provided with a death certificate. That sometimes is enough to suffice for FEMA. So there is a little bit of wiggle room there as well. And the purpose of home repair assistance is to make a survivor's home habitable. It is not to repair it to the point of what it was before the disaster. So FEMA's definition of uninhabitable is a dwelling that is not safe or sanitary. Now they've changed the definition to exclude disaster caused in there, and same for safe and sanitary. They removed that disaster related addition to the definition. So now the definition is safe, being secure from hazards and threats to occupants, and sanitary is being free of health hazards. And the reason they did this is because there has historically been an issue within FEMA where inspectors or the agency has taken a stance that if a survivor had deferred maintenance on their home, then they would say that damage is not caused by the disaster, therefore we are not providing home repair assistance. So we would often see this with our lower income clients who maybe had a leaky roof before, and then all of a sudden they're no longer getting home repair assistance because FEMA said, well, your roof was leaking before, you're not eligible, deferred maintenance. So they kind of adjusted the definition of habitability, safe, and sanitary to kind of undo that. And we are still in the process of seeing how that works. It'll take several years to see the outcome and the progress on that. So that means that applicants' home repairs now are eligible for financial assistance regardless of those pre-existing conditions. Next slide. Home replacement assistance is another form of housing assistance. It is likely to come up a lot in this disaster, just given the nature of the fires. As survivor will have to be able to show that they are a homeowner. This type of assistance can, and we often see it combined with the combination of an SBA disaster loan for a homeowner to be used for a down payment or for the rebuild. These do require higher levels of approval. So any request for home replacement assistance will be approved by the regional administrator. And that's just an extra level because of the type of assistance it is. And the money is to assist with the cost of replacing the destroyed home. So there's no repairing it. We need assistance to completely replace it. Like I said, it's not going to be enough to cover the entire cost of the home, which is why we often see them paired with those SBA low interest loans. But it is available to survivors. Next slide. Now we'll move into other needs assistance. Thank you. So there are several different types of other needs assistance available to survivors. We're going to go through a bunch of these here, but know that this miscellaneous category, you can argue for anything. There are a handful of things that we typically see. So generators, we see after a storm, different types of equipment that wouldn't generally fall into something such as, childcare assistance or cleaning and sanitization assistance. It could fall under that miscellaneous assistance. Next slide. So the big one we often see is personal property assistance. And this is financial assistance to help a survivor repair or replace damaged personal property. It has to be the personal property of an occupant of the household, and the damaged item has to leave the disaster survivor with an unmet need for that item. So the common thing we typically see this fall into this category is appliances. And it sounds silly, but somewhere one day someone had to have argued this and it became an example. But FEMA will not pay for a disaster survivor to have 2 microwaves if one of those microwaves is working, right? But they will pay for a survivor to have an oven and a microwave repaired or replaced, even though those are both meant to heat food and conduct things like that. So when you're dealing with appliances, even though the purpose of the appliance does the same thing, it's really more about the fact that it's not the same appliance in most situations. So the microwave, the oven, the fridge versus the standalone freezer, those are all things you can argue on behalf of your survivor. And then the other really big thing we see here is that landlords sometimes, a lot of times, often put pressure onto disaster survivors to try to claim personal property damage of the landlord's owned appliances. So refrigerators and dishwashers and things like that. We often see landlords doing that. Landlords are not eligible for FEMA individual assistance for rental units. So there's a lot of advocacy that goes into making sure that tenants do not put that on there, because it is not to be paid for by FEMA, and we don't want the tenant ending up in some sort of recoupment proceeding because of that. And then items by guests who are not members of the pre-disaster household are not eligible for assistance. Next slide. So we went over the appliance example. Clothing is another really big one that we often see. It's not intended to cover an entire wardrobe. FEMA will provide assistance for clothing that has either been destroyed, physically gone, or contaminated by a chemical or sewer backup. So something that can no longer be just washed and be worn again. Generally, what we have seen is FEMA pay somewhere between like 3 days of clothing to 5 days of clothing. It's not a lot. And often they will not pay for, like a winter wardrobe that was stored away in a room. They're going to pay for what the survivor needed and was using at the time. So if they had a large collection of clothing that they were storing away, probably not going to be replaced or receive financial assistance for that. For room furnishings, specifically for the bedrooms, FEMA is going to want to know that that bedroom was occupied. So if you have a client who had a 3-bedroom apartment or house, but only 2 of those rooms were actually being physically occupied or slept in, and the other one was kind of being used as an office or storage unit, FEMA is only going to pay for the damage and the furniture in the 2 occupied rooms. So you want to go through with your client room by room by room to make sure that you fully understand what was in that room, but also whether that room is going to be considered occupied by FEMA standards. FEMA is generally going to pay for bedrooms, kitchen, bathroom, and a living room. So rooms that are generally occupied. And then they're going to look at the level of the damage to the room and the items and determine if those are repair and replace. There have been some changes under the essential tools assistance available for survivors, mainly for those gig workers and self-employed workers are now eligible to have their essential tools repaired or replaced. Previously, before the rule change last year, self-employed workers weren't really able to get their tools replaced by FEMA because they weren't able to show that it was required by an employer because they're self-employed. So that should no longer be a barrier. School supplies and schools, if they are required for school, but they are not being reimbursed or covered by a school, FEMA can help with that. Uniforms are the same. Computers are now eligible regardless if they are for work or educational purposes. Previously, that was a requirement. That is no longer a requirement. And then additionally, under computers, there's also, if you need it for an accessibility purpose, you can argue that as well. Next slide. Transportation is also another really big one. The vehicle is going to have to be in compliance with state law. So registered with the state and insured based on whatever the minimum requirement is. That's at least what it is in Texas. I imagine California has very clear laws on what can and can't be driven and what is in compliance with their law. So it has to be in compliance. The vehicle has to have disaster caused damage, and that damage had to occur within the disaster declared county. They're generally looking at vans, trucks, sports utility vehicles, cars. We've had people try to argue because we have, like beach towns and things. So we have had people try to argue golf carts as vehicles, boats, all kinds of different things. So you can keep that in mind, but there is a general list of what FEMA considers to be a vehicle. The vehicle can't be a rental. So it's either owned or leased by the survivor or the household member. And then the applicant can't have a second operational unaffected vehicle. So if there are 2 vehicles in the house, one is damaged and one is not, unless you can explain to FEMA why the household needs 2 vehicles, they won't pay for the damage to the first one. It's really easy to explain why they need 2 vehicles. Maybe one person has to take a child to school and the other has to go to work, or they both have to go to work. Any of those reasons are sufficient. You just have to explain that. Next slide. Next slide. So going into that new serious needs assistance, the big thing here is it was previously known as critical needs assistance, and it was only provided for after certain disasters. Now it is available after every single disaster. And that is what you're probably hearing happening right now is a cash payment of $750 going out to survivors. It is for survivors who are displaced from their pre-disaster primary residence because of the disaster, or they are sheltering in their pre-disaster residence, but they need to shelter elsewhere. And this serious needs assistance is supposed to help with food, water, diapering, moving to a different location in order to find safe shelter, formula, personal hygiene items, maybe gas or anything like that. And then FEMA or survivors can apply for that on their FEMA application by stating that they are either displaced or they are in their home but need to be sheltering elsewhere, and that should kick in for them. Next slide. So displacement assistance is a new program. This did not exist prior to early last year. And displacement assistance is a one-time payment that FEMA can provide for up to 2 weeks of financial assistance for temporary lodging. So as previously mentioned, there is the transitional sheltering assistance program, that voucher program where FEMA pays the hotel directly. This is money that would go directly to a survivor where they could use it to pay or reimburse themselves for a hotel or motel stay or for a stay at a friend or family member's home. This money goes directly to the survivor for them to be able to temporarily relocate. It's supposed to be based on 14 days of hotel cost at a rate that was chosen by the state. And so the big one here is for survivors who have insurance. If their insurance covers additional living expenses or loss of use coverage, then they are not eligible for displacement assistance from FEMA. That would be a duplication of benefits. So you'll just want to make sure to be really clear with your clients there that if they have that insurance coverage, they should not be asking for displacement assistance from FEMA. Next slide. Okay, so FEMA inspections, the purpose of it is to establish that the home is uninhabitable and that the home needs repairs or needs to be replaced. The inspector is basically FEMA's expert. I will tell you they are not often very qualified. They don't have to have a ton of construction experience. They get trained very quickly and on the spot. They are tied to independent government contractors, and they receive minimal training on housing standards. So really, the FEMA inspector is there to catalog the damage. They'll walk around with an iPad and talk to your survivor, hopefully, about what the damage looks like to their home, their personal property, their transportation, all of those things. It is very important that your client, the disaster survivor, if they are available, be present at this inspection, because the FEMA inspector is going to verify home ownership and occupancy every single inspection. So even if they've proven it and FEMA knows they're the homeowner, if the inspector comes and they don't show them the ownership documents, they're going to get denied for home ownership, not verified. It's ridiculous, but at every single inspection. So if they can be there, it is best for them to do that. It is also important for them to be there so that they can advocate for themselves, and also ensure the quality of the inspection, to make sure that the inspector is actually looking at their property and not doing a drive-by inspection where they just take a picture of the outside of the home and then leave. We've seen all of those things.
I just want to flag quickly, the total destruction of the majority of these properties.
Right.
We don't know yet, and we'll try to do that work on the NLS side to find out like where the list is or like how people like what stage they are in this. I think that will be like a lower need or a lower delay in these.
Right.
Although there are going to be some people who just had some fire damage and not complete destruction, but it's pretty much complete destruction.
Right. So in those instances, I imagine the inspector will just go out and say, yeah, the home is completely destroyed. In situations where I see this coming up more, maybe for homes that have a lot of smoke damage, or personal property that has been damaged by smoke, the inspector is going to want to look at all of that and determine that and whether or not that can be aided by home repair assistance. Do they need to rip the drywall out and do all of that and replace it? Or is it a cleaning and sanitization issue that they can provide assistance for? So it might come up in a couple of different ways that aren't what you traditionally would think. The other thing is that inspectors don't go on roofs and they don't go under homes, but that's just two limitations that they have. Next slide. So what does a FEMA inspector decide? They determine who has home ownership and whether that's been verified. They determine if your client actually occupied the home. So they might look at a driver's license and make sure that the driver's license address is up to date, or maybe a utility bill. They're going to determine what the damages and losses are, whether that affects habitability, and what other essential items or serious needs that the survivor has. Next slide. And then generally, this is kind of a timeline of what this will look like. So within 10 days, a survivor should get a determination letter from their inspection. As I mentioned, in larger scale disasters, it can take 90 days. The letter will be followed by a financial assistance if approved, or an opportunity to appeal that decision if they are denied, or if the financial assistance amount is not enough. The applicant may need to amend their application based on changed circumstances, and then FEMA might send pre-decision letters to request supplemental information from your client. Next slide. Okay, I'm going to pass it over to Hannah.
Okay, hopefully you all can hear me and see me. I am going to be going over appeals. I'm going to try to go pretty quickly to try to get through the information as fast as I can. So this is the most important slide. What documents are needed for an appeal? Appeals follow the same basic formula every time you do one. No matter the cause, no matter what you're appealing, it's going to follow the same basic kind of outline of what's going to go on the in the appeal. So you're going to start with a cover letter. That's going to contain your applicant's name, their FEMA number, the disaster number, their pre-disaster primary residence, and their current phone number and address. You're also going to have your FEMA authorization. Brittany talked about that earlier. That is the letter signed by your client giving you permission to speak, giving FEMA permission to speak to you directly instead of having to wait for your client. You also have to have the government issued ID, and the declaration. The declaration is your client's statement about what is happening. And then you'll also need your evidence. So the specific information in your cover letter, your declaration, and what your evidence is going to vary based on the type of denial they've received and the type of appeal you're doing. But the basic outline is going to look the same. So that's the template: cover letter, your FEMA authorization, your client's ID, your client's declaration, and then whatever evidence is necessary. Technically speaking, before we go to the next slide, under the new rule, the cover letter and the declaration are optional. You will see as we go along, for some types of appeals, your declaration is the only evidence you have. There's no other evidence other than your client's signed statement. So the declaration is basically required. There are certain types of appeals that now allegedly you don't have to submit the cover letter or the declaration. We probably still would if you have the time to do it. They tend to, your cover letter and your declaration tend to kind of follow a template, so it's not too hard to do. So we would recommend probably still doing them, but technically they're not required under the new rule. All right, next slide. So this is the new form that you can use to submit your appeal request. We don't know yet. I don't think we still know yet whether FEMA is going to deny appeals that don't include this form. This is the form that your client would put information on, and this would replace the declaration. I would probably try to use this form because FEMA, I suspect strongly that there will be cases where you don't use this form and then FEMA denies it because they're looking, the person reviewing the appeal is looking for this specific form and they don't see it. And so you'll say to them on the phone, well, my client signed a declaration, it's right here, it was just in a different form. And they will say, yeah, well, I don't see I don't see the appeal request, so there's been no appeal. So I would probably recommend using this form if you can. All right, next slide. So if you have a FEMA file, quickly, we will go over this. Brittany talked about it earlier. The FEMA file has the copies of correspondence between your client and FEMA, and it can have inspector comments, which can be really useful. It can have FEMA decision maker comments, and so it can tell you sometimes what the award, if your client has received awards, but you don't know what for, if your client has been denied, but you can't tell why, those inspector comments could be useful. It's not as comprehensive. Our understanding is that the inspection report's not as comprehensive as what FEMA actually received from the inspectors, but there should be some notes in there. So it could be useful if you can get it. As Brittany said earlier, sometimes you can, sometimes you can't, but I would always request it, and then that way you can try to see what they have and see if it could be useful. So one example would be if your client's been denied for rental assistance, but the inspector comments show a bunch of damage, then that might give you an idea of, okay, so FEMA knows that this person's house is not safe to live in. Like, they recognize that. We're missing something else. Like, there's something else going on that's the reason they're being denied. So let me try to address what's actually happening versus, I don't really know why they've been denied or what's going on here. So we'd ask for it. You may have to do your appeal without it, but, kind of see what you can get. All right, next slide. For serious needs assistance, you can go on to the next one. Perfect. For this, what type of evidence is typically needed? If it wasn't automatically awarded to the client, you probably need to request it in a cover letter and a declaration. So this is going to be one, like I said, where there is no evidence other than your client's statement. So something saying the applicant's displaced from their pre-disaster residence because of the disaster, or they're sheltering in their pre-disaster residence and they need to shelter somewhere else because where they're staying is not safe. So that's what what I would do is a cover letter that explains that, a declaration signed by your client stating that, and then of course, as always, you'll need your FEMA auth and your ID and submit that into FEMA and see what they do with it. Next slide. Oh, okay, sorry, that is the next slide. Okay, so rental assistance. What type of evidence is usually needed in initial rental assistance? So typically, if your client's been denied for rental assistance, you're going to need a declaration stating the damage, explaining the need for rental assistance, specifically stating that they're willing to relocate, and you may need to include a permanent housing plan. If you can tell why your client was denied for initial rental assistance, either because they told you over the phone or because you can see it in the FEMA file or on the denial letter, you may be able to address specifically the issue. But generally speaking, the reasons that you're denied for rental assistance is that FEMA thinks the home is safe to occupy. That one's harder to overcome. And I think you will get some of those. I know earlier it was mentioned some of these homes have been completely destroyed, so you probably won't get home safe to occupy for some of those. But there will probably be homes that are smoke damaged that FEMA will say, no, it's safe to occupy, and it will be denied. I don't know that will happen, but I suspect that will happen. The other common reason Brittany said earlier, to just restate, is that FEMA will ask, the FEMA inspector will come out to the home and ask the individual, are you willing to relocate? And the person hears the question, thinks, no, I want to stay on this land. This is my land. I bought it. I want to stay here. I want to rebuild here. And then they will think, no, I'm not willing to relocate. But that question's about temporarily relocating. And so if that's the only issue, FEMA says they're damaged, the home is damaged, and it says that they've said that they don't want or need rental assistance, that can be fixed very easily with the declaration saying that they do in fact need that rental assistance, and that should fix the issue. So again, you're going to do cover letter, declaration, and then if they do need some type of evidence to show damage or something like that, you'll have to include that as well. So next slide. You can also deal with insurance. I won't go into that because that can take a long time. But if you do have insurance, you will have to show that your insurance does not meet your temporary housing needs. And then, if you'll need to provide evidence that they don't have anywhere else to go. So if they do own an available rental property that would meet their needs, then they're expected to move into that rather than ask for rental assistance from FEMA. So next slide. For continued rental assistance, so this is after you've gotten the initial rental assistance and you need more, which probably has not happened yet, but will be happening in the next couple of months. So you'll need a declaration stating why they can't return to the pre-disaster housing. You will have to have the permanent housing plan. You need a copy of the lease or rental agreement signed by the landlord and the tenant. So you have to show that you've made an agreement with someone to use that rental assistance that you've already been awarded. You will need receipts showing that you've used the rent. It can be used for security deposits. It used to not be able to be used for security deposits, but now you can use rental assistance for security deposits and for essential utilities. You'll have to show your proof of your post-disaster income, so current income, pay stubs, etc., and then proof of your current pre-disaster housing costs. That would be if they have a mortgage statement. So if they're still paying on a house that they can't live in, then you would need to provide proof of that. Next slide. I would now say one last note on the continued rental assistance. It is harder to get continued rental assistance than it is to get rental assistance. I've done it. You can get it, but FEMA is much less willing to give that out. So I would not, when you're talking to clients, I would not tell them, oh yeah, FEMA is going to pay your rent for 18 months, because that is not, that is often not the case. There will be a cutoff at a certain point. So, okay, now we can go on to the next slide. Occupancy denials are typically pretty easy to overcome. Again, as Brittany said earlier, you have to show that you occupied the property at the time the disaster occurred. The most common thing that people use to show that is their driver's license. So if your driver's license does not match your address, or is expired, something like that, then you're often going to get a denied case, a denied FEMA appeal, based on occupancy. Very easy to overcome this most of the time. Utility bills, merchant statements, employer statements, a leasing or housing agreement, rental receipts, any of these things that have to be dated within 1 year prior to the incident period will overcome the occupancy issue. So what you would submit in this appeal, this is one where you may not have to do a cover letter or a declaration. So you could, in theory here, submit to FEMA the FEMA authorization, a copy of your client's ID, and then just whatever piece of evidence you're using to show that they did in fact occupy the property at the time of the disaster. I would recommend, if you have the time, I know you guys are going to be slammed and not probably have a ton of time. If you have the time, I would write up a declaration explaining, like, I was denied for this reason. I did occupy the property at the time of the disaster. Attached to this appeal is a utility bill from such and such company showing that I've resided in the property from X date until the disaster. I would include something like that, just so the FEMA person reading it can fully understand what's happening. So that's occupancy. Ownership, we can go to the next slide. So this is ownership if there are traditional ownership documents. So this is going to be, they own their home, they have a deed. You probably won't get a ton of these. They do happen where the FEMA inspector just can't find the document for whatever reason. FEMA just, has a mess up, basically. You will get some like these. Some I've seen is if, for example, and California is community property as well. I had to think about that for a second. But some that I have seen is if the person applying for FEMA assistance as the head of the household, their name's not on the deed, right? So maybe they're married to the person whose name is on the deed. You may have to explain, like, hey, we don't have the same last name, blah, 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 whatever. That's my husband, that's my wife. We own the property together. My name's just not on the deed. Or it's somebody in our household is the owner. It's just not me, the head of the household. And so I have won appeals like that. So you will see some of these. Typically, you just need to submit a declaration explaining what's going on if necessary, and then a deed, a mortgage statement, a real property insurance document, or a bill of sale will all work for this type of thing. These are pretty easy to win and not super difficult. Next slide. So now we're going to talk about ownership when you do not have traditional documents. So for this, you can't, FEMA standard is that if you occupied the home and you did not pay rent, and you either pay the property taxes or you pay for repairs, you are considered the owner for the purposes of FEMA assistance. Meaning, in theory, if FEMA wants to get the money to the person who's paying for repairs, right? So if your client lives there and they don't pay pay property taxes, they're not the named owner, but they don't pay rent and they do pay the property taxes, or they've paid on a utility bill, then you can submit proof of the property taxes, proof of utility if they have, or proof of repairs if they have that, and then a statement from them saying they don't pay rent, but they do live there, and that should work. If you can get the owner of the property to sign something saying that they don't pay rent, and that that the person who occupies it is responsible for repairs and for property taxes, even though they aren't the legal owner, that would be phenomenal. But you can win these appeals even without having the person who actually does legally own the property sign something. And also, Brittany mentioned earlier, if California has some kind of, I don't know if y'all do, but if there are any kind of non-traditional ownership documents that other states don't necessarily recognize, that should work. FEMA is supposed to go by what the state law says. But you may have to explain, yes, I know this document isn't typical. You may not have seen this document. However, it is an ownership document in the state of California. Here's the law, and move on forward from there. So next slide. I'm not going to read all of this, but you can use a self-declarative statement if you own a home, live in an insular area, island, or tribal land, or in a travel trailer or mobile home. You don't have any acceptable documents. And if it's a last resort, it does say there what has to be included. And if you go to the next slide, that is a statement that has to be included in the declaration from your client. So this is one where your client must sign a declaration. It's not an option to just, there's no documents to submit. So you have to submit something signed by the client with this statement or substantially this statement in order to get that self-declarative statement. This is a new thing. Trala hasn't had a major disaster since this has gone into effect. I'm unsure how much FEMA is actually accepting these, but hopefully they will.
I just want to say that all of this guidance is completely critical and we do want it and we're recording it. So if you have to leave, we're sorry. This is taking a little longer than we allocated time. If you can stay, awesome. If you can't, again, everything is being recorded. Our chat is going to be sent out with questions. And yeah, I think everyone should agree it's much more important we get all this critical information from the folks at TRLA than we stop the training. So we're just going to keep going. If you have to leave, we really, really appreciate you being here. Remember, I'll put the MCLE in the chat one more time and the volunteer form. There are so many good questions and so much desire to help. It's so great to have all these lawyers together asking all these amazing questions, but we're just going to have to take cases like on a case-by-case basis. So, do whatever you can, volunteer however you can, but again, be patient with us because our capacity to respond to all the interest is a little limited. But yeah, let's just keep going and I'll drop those things in the chat.
Okay, so you can also use this self-declarative statement for airship. So this is huge. If the person if the disaster survivor owns the home and lives in it, but they only own a portion of the home because it was passed down via airship, and they don't have any acceptable forms of ownership, this is really, really big. They can do a self-declarative statement as a last resort. And so we expect that this will be really helpful, especially for clients who are most at risk, those who are low income and don't have access to attorneys as much as perhaps people with more resources. And so therefore, when dad who owned the home passed away, they never went in and were able to clear title because they could not afford to hire an attorney to handle that issue. So this is the big deal. Hopefully FEMA will honor it and respect it. I suspect some of you will have to fight with FEMA to get them to accept some of these, but I think it can be done. It's written down that it can be done now at least. So the next slide does have the statement that has to be included for a declaration by your client when asking for FEMA assistance based on airship. Okay, so the next slide, we're going to go over a denial for home repair when the home is considered safe to occupy. Again, I do want to go over this. For most disasters, this is the most common reason we see for a denial. It's going to play out differently for y'all because hurricanes and floods don't destroy houses the same way fires do, obviously. So it's going to be obvious for a lot of your people, for a lot of your survivors, that their home is entirely destroyed and not safe to occupy. But I think that this will still happen. I think that there will probably be, damaged homes that are not destroyed, that FEMA will still use this. So I'm going to go ahead and go over it. What you need is a declaration stating the home is not safe or sanitary. The definitions are there. You need a contractor's estimate. This is the biggest piece. This is your evidence when doing when doing a home is safe to occupy appeal. It has to be detailed and itemized. And then FEMA will call the inspector to confirm that they prepared the estimate and that they did look at the house. And they don't ask a ton of questions, we don't think, but they will call. So you do want to make sure that the contractor's estimate, that the contractor is going to answer the phone when FEMA calls. I don't usually submit photos. It could be useful. FEMA says they don't look at them. You can submit them if you would like to, but it's not, if you're, pushing up against your deadline, I just submit it. Don't worry about waiting on those photos because it's not probably going to make a huge difference for FEMA. That contractor's estimate is the most important thing. And so then one goal of the appeal is not to get cash assistance, but to get a second inspection issued. So essentially when FEMA sends an inspector out, if they get a contractor's estimate saying, oh, you didn't consider all the damage, here's some additional damage, that first inspection was wrong, they will send a second inspector out to verify that the first inspector was correct. So what you're not going to get is, oh, FEMA granted you $10,000 for home repair, and now you have a contractor's estimate saying there's $30,000 of damage. FEMA's going to write you a check for $20,000. That's not how that works. What will happen is they'll send a second inspector, and hopefully that second inspector will log damage that the first inspector did not do, and then that will get your client more money. All right, next slide. So we're going to go over denials for insurance. I'm not going to go over this in a ton of detail because we are running out of time, and insurance denials can be very tricky. But you want a declaration from your client. Again, you want a denial letter showing that you're not being covered, or a settlement letter stating what is being covered by your insurance company. The way FEMA generally works with insurance is that if you have no insurance, obviously they'll cover it. Or if your insurance coverage does not cover the damage that has been caused to your home, then FEMA will cover it. If what's happened is that your insurance company says, we're gonna give you $15,000 for this damage, and you have an inspector that says, well, there's really all of this other damage, and the insurance company is just like, well, we're not going to pay for that. In that situation, FEMA is not going to cover it because somebody else has looked at it and said we're not going to cover it. If the insurance company said we're not going to cover this because we do not cover this, your insurance policy does not cover this type of damage. It's damaged, but we don't cover it. In that situation, that's an uninsured loss. And FEMA will potentially cover that. So it can get a little tricky, and you kind of have to dig into what exactly FEMA, your insurance company, covers and what they don't. You can get, with a delay letter, you can show the insurance company still considering it. It's been more than 30 days, so you need that assistance. That can also get tricky because then if the insurance company comes back and gives you assistance, you're going to have to square away whether or not there's a duplication of benefits between what FEMA gave you and what the insurance company gave you, and you may have to pay money back to FEMA. So if your client really, really has to have the money, it may be worth dealing with that hassle for them, but it's just something to keep in mind. Next slide. Okay, so denial for other needs assistance. There's a broad variety of things here, but again, generally you're going to need the declaration, the FEMA registration or FEMA authorization, ID, and then your evidence. Depends on the type of assistance. For transportation assistance, well, essentially for every single type of assistance, your evidence is going to be the things you need to qualify to get it, right? So if it's transportation assistance, what does FEMA not have? They have to have the title, the registration, a description of the vehicle, a bill for repair, if necessary, verification of insurance or verification that it complies with state law and is a drivable car and was a drivable car at the time of the disaster. So all of those things, you're just going to kind of have to see what was missing in the FEMA appeal, and submit that. Potentially the explanation for why they need more than one functioning vehicle. For personal property, your evidence is going to be a detailed list of items. It's helpful to list that the room is occupied. You want to give estimates of repair if you have them. Most people are not going to get estimates of repair for a refrigerator. That's, people don't really do that anymore, but if you have those, you can get them. And then also receipts showing the applicant owned the property if you have them. A lot of people, the only thing the only evidence they're going to have is the detailed list of items categorized room by room. So you'll want to get that. So next slide. IDV fail. So this is a common one when there's a mixed status family. So again, as we've gone over at length, children could, a child, a 6-month-old could be considered the head of the household for the purposes of FEMA assistance, but children often don't have an ID or a passport. So the FEMA has to verify that they are eligible and that they're, a citizen or a legal permanent resident. And in order to do that, they want to check their social security number and their ID, which if you're 6 months old, you're not going to have that ID. So this used to be kind of harder to overcome when I first started doing this work. It's not typically that difficult now. So you can see there, submit a copy of their birth certificate and their social security card or any document from other federal entities containing the full or last 4 digits of the child's social security number. Should work to clear that up. Okay, so that was kind of the last of what I was going to go over. I don't know, Brittany, if you want to go over anything in these last slides. We are pretty much out of time. Is there anything
Yeah,
critical
there's
in
one
there?
thing. Can we flip to slide 60? Because I know it's a question that a lot of people have asked about. But it's about crowdsourcing and GoFundMe. It's going to be labeled duplication. There you go. And so by law, FEMA cannot duplicate a benefit that is received from another source. So this is going to come up a lot, especially in this disaster, because there's a ton of crowdsourcing and donations and crowdfunding going on. Generally, the way this is looked at is if a GoFundMe is very specific and they say that they are raising funds to replace the car. If FEMA provides transportation assistance, FEMA is likely going to view that as a duplication of benefits. Now, what does that mean? FEMA can, it's called recoupment, but it's basically debt collection. And so if they think that they've paid for something that a survivor's insurance is paid for, or that the Red Cross is paid for, or that a crowdsourcing thing like GoFundMe has paid for. If the survivor got money from anywhere else to pay for that thing, they're going to debt collect or recoup. So you'll want to make sure that your client does a couple of things. This is what I would do as an attorney, and my practice tips that I would tell my client, and that is, if they are going to set up a GoFundMe, I would ask them to do it in a way where it is for general disaster recovery rather than very specific disaster related needs, right? That might not be great for a GoFundMe website, but that's going to give you the best argument to argue that maybe it was used for something not covered by FEMA or not covered by a client's insurance. The next thing I would do is I would go ahead and advise my client and start preparing them for the possibility of recoupment. And the best defense to recoupment is, one, complying with the deadline. So they are very strict about recoupment deadlines, unlike appeal deadlines. And I would tell them to keep detailed receipts of how they spent the GoFundMe funds to show that there is no duplication of benefit that overlaps with FEMA assistance as it was paid out. That's the best thing that we can tell them. Ultimately, I think it's going to become a big mess, like it usually is after these disasters. And whether or not FEMA has the resources, the staffing, and the ability to go in and investigate these recoupment cases, that's just going to be something we have to wait and see on. Some disasters tons of recoupment cases. Other disasters, not so much. So it's really kind of up to them. Discretionary recoupments, we have been told, are random, that they just pick a handful of cases. That may be a crowdsourced case, it might not be, but that's the advice I would give my client. Be general and keep lots of receipts. And then I think everything else that's left on these slides, they're best practice tips that we use in our daily practice. So a lot of it's kind of reiterating what Hannah just went over or what I went over in the beginning. So we're just going to let that sit. I've done my best to try and answer as many questions in the chat as possible, but I am sure they will tell you a way to get a hold of us if you do have more questions.
Why don't we go to maybe one of the last slides so you can see all the resources. Yeah, but flagging, which one is the one that's not updated since 2021, but it's like the FEMA official guide, right?
Yeah, so the Individual Assistance Program and Policy Guide, that's basically FEMA standard operating procedure that they're willing to publish to the public. They have their own very detailed SOP on their side that we're not allowed to see, but this is the public facing document. This is going to give you your lists of documents that your client can submit, the eligibility standards. It's going to detail everything for you. It is a PDF, it's Control F searchable. It is very, very helpful when working on these cases. Now, not every situation is covered in the IAPCA, but a lot of it will give you the foundations for your arguments.
Mm-hmm. And are you able to stay a little bit while longer if people do want to hang out? Okay, so yes. So I will just say thank you again. Like I've said it like 10 times, but we are so grateful. This is a wonderful example of legal aid working together under these very difficult circumstances. Again, I put the MCLE, let me just put it one more time, a million times. Please get your MCLE. All of this will be shared, but for people who want to stay, there still are a few questions. I personally have questions and we're recording this, so it will be available. So just be aware that when you're talking, there's actually continue to put questions in the chat and I will field them. I did have one question that I put in the chat, so I'm just going to take liberties. We had a gentleman who was subletting. He was homeless and precariously housed, and he was subletting without the landlord's knowledge at the time of the disaster. Is that something that can be overcome? Is that considered occupancy or not?
I think that's less of a problem for FEMA and more of a problem for when his landlord finds out. So if there's like some sort of written document or contractual obligation on that sublet, then I think the person whose items were damaged and they were subletting can use that as almost like a lease for the purposes of FEMA. I don't know California housing law on
the unit was destroyed. Yeah, the unit was completely destroyed. So I think that's also an issue. But okay, as long as there's some, whatever was on his side. Okay. Yeah. Do folks want to like repeat any questions that haven't been answered yet in the chat or raise things up anew? The deadlines and getting extensions, people are asking about that.
I can address that one. The deadline to apply for FEMA, so not to deal with appeals, to actually apply. FEMA has typically been very strict on that. Like if you're in a coma and you woke up the day after the day after the deadline to apply to FEMA passed, then you might be able to get that. But they don't really give a lot of leeway on that. Deadlines to appeal decisions, we have typically found they're very lenient. So it's typically the deadline is 60 days from the date of the denial letter, not the date the client received it, but the date listed on it. I would, if you're appealing late, I would put in the declaration that, I know this appeal is late, however, I'm requesting that FEMA consider it anyway. It's late because, and put any explanation they have. I didn't know I could appeal. I didn't know whatever. I didn't know how to appeal, something like that. But generally, FEMA will respond to those anyway. I would never like turn a client away because they've come to you on the 61st day of the appeal. I would submit that anyway. FEMA usually doesn't, they're not that strict about that. Once you've hit your, I forget now the name of it, There's a point at which FEMA is like, we will not take any more appeals after this point. They tend to be, they're strict about that one too. But up until then, I would not worry too much about the 60-day deadlines.
We have questions about the typical timeline for applying for certain types of assistance, how long it takes and what you can expect. I'm curious about this too, because some of them are so critical and needed immediately. Like same gentleman didn't have money for gas to get to the shelter that was being offered to him. So how fast for serious needs, how fast for rental assistance, and then the longer term stuff.
Yeah. So in practice, serious needs should come out immediately upon the application being done. If they set up a direct deposit, that should show up within a couple of days. Practically speaking, what we have seen over the past year is sometimes survivors, and I would just encourage all my clients to do this at this point, is to just like submit their application and then specifically write FEMA and say, I want serious needs assistance. Because for some reason, FEMA is having this large delay. We saw it in North Carolina, in South Carolina, Georgia, and Florida after the hurricanes this summer, where for some reason FEMA was not actually paying out the serious needs assistance, even though the application showed that it was approved until someone asked for it. And that's a really dumb reason to have to wait. So while we can push to get them to do that on their own, I would just go ahead and tell them to get that done, because that is a type of assistance that should be done before an inspection. It should purpose is to get it paid out as soon as possible. All the other types of financial assistance for home repair, personal property, and all of that, if they are approved after the inspection, it should come a couple days after that. Direct deposit, much faster. There is an option for a check. In our experience, sometimes those checks take months. So I would highly encourage a direct deposit option if it's available to them.
Okay, I'll try to read a few more. What if an owner whose primary residence was completely destroyed it has a secondary property, but it's occupied by a renter? So they can't live in it
So they
without
should be,
evicting.
I was going to say they should be eligible for FEMA assistance generally if they meet all the other requirements, right? For their primary residence. Their secondary residence, or secondary property, if that sustained any damage, they might look into an SBA loan for that. And then the renter would be eligible potentially for their own individual assistance. But whether or not they have multiple, they may ask you to show that the other property is listed or is leased. You might provide a copy of that lease, but I would just proceed. They are eligible on the primary residence.
Okay, we're also getting some questions, and I've seen this at the center with people having the same address, but believing that they're separate households. In this case, in the question, there's actually 2 units on the same property, but same address. And in some, there's people living in the actual same property, but they function as 2 households. So they're getting denied because application's already been made at that address.
Yeah, so we see this a lot too. The FEMA IAPCA actually has a section on what they call boarders and then roommates, and then they have different standards for those. So I would highly encourage you to look directly into that. What I can tell you practically is we've had multiple. I've had people in the same house, but they're both renters. So one application, the real argument, the foundational argument there is you're going to want to argue that they're 2 separate households. Even though they're in one house with the same address, your argument is 2 separate households. And that you have a distinct way of showing that the property, personal property, is linked to which survivor, right? The issue we come across is like these ADUs that are in people's backyards where we don't have a great way, right? We make the secondary, or sorry, we make the 2 household argument. And sometimes it works and sometimes it doesn't. And that's the really problematic thing with FEMA is they're not consistent. But yeah, I would look at the IAPCA and use their policy to make that argument. But those are really difficult cases.
Yeah, because one thing, if FEMA has already paid out, and because they are calling you a joint household, like one household, and they've already paid out assistance for all the damaged property to one household, what FEMA is going to say is, well, you need to go get your money from the other person.
Right.
So it can get ugly as well.
Okay, thank you. Okay, most people who have insurance will find that they're in some respect underinsured. Can you give examples for when FEMA says you were covered versus when they'll determine you were not or were underinsured? What does it typically look like when they actually do determine you're underinsured?
Yeah, so the way that I've seen these cases come in is the insurance company has given them the detailed list of claims that they're going to pay, and then you take that and you submit it to FEMA with an estimate from a contractor. So the contractor's estimate is, you know, $400,000 to repair, rebuild this home. The insurance company paid, you know, $300,000 for it, and now there's this $100,000 discrepancy here. That's when you're going to want to use your contractor estimate as your evidence that you have an uninsured loss that FEMA needs to help with.
We're also seeing people who have the property insured but don't have temporary lodging covered and do have a need for financial assistance for temporary lodging, which we're seeing a lot of, especially in the Eaton fire, elderly, disabled, many people, households with people of color who don't have that coverage. And it seems like FEMA understands that piece.
Yeah.
So that's another example of being underinsured. My understanding was the deadline is March 8th because the disaster was declared on January 7th.
It's actually the 10th, according to the FEMA website.
Oh, really? Can you
Yeah.
put that in the chat? 'Cause we were
Sure
looking
can.
for it. Okay, cool. Thank you. Okay, we have some very specific. So about duplication of benefits, when you're getting cash aid like foster care or TANF, that does not impact your FEMA. That is considered, income is not a factor for FEMA. So just so everyone understands, there are no income and resource limits for FEMA. It's a duplication of benefits issue for FEMA.
Right, and FEMA assistance should not impact any of your needs-based financial assistance as well. So it's same way.
Right. I think there's a little bit of a tricky question, maybe if you get from CalWorks, if you get temporary housing, like rental assistance. I don't know if it's the same in other, like that's maybe more specific to California, but we'll deal with that as it arises locally.
I also think, because I saw the question about the foster kids, I think if California does end up doing some kind of program for like, oh, the state's going to pay for the foster child's replacement of clothes or something like that, that could be whose household is that child a member of, and that could get tricky because if the state ends up paying for something like that, if FEMA has considered that child part of the household and has given money to the household for that, that would be a duplication of benefits. So it is tricky.
Let's see, are we missing anything? Thank you for that. The deadline is the